Chalo. Can you hear me? ಧ್ವನಿ ಕೇಳ್ತಾ ಇದೀನಿ ನಂದು? ಈಗ let me finish it because we have all that questions now. Previous question papers, mock test papers ಎಲ್ಲ ಫಸ್ಟ್ ಮಿನಿಟ್ ಆಗಿಂದು. ಬಟ್ ಅದಕ್ಕಿಂತ ಮುಂಚೆ we'll discuss some of the remaining part of the chapter. Once we finish that offer and acceptance, definitely we can go for it, right? So bacha, here we have the last part of the Indian Contract Act Unit 1. After this we have consideration. Consideration ಮುಗಿಸಿ we can. ಈಗ ರಿವೋಕೇಶನ್ ಆಫ್ ಆಫರ್. ಆಫರನ್ನು ಯಾವ ರೀತಿ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ಕೋಬಹುದು? ಹೌ ವಿ ಕ್ಯಾನ್ ಕ್ಯಾನ್ಸಲ್? ಕೇಳ್ರಿ, ನಿಮ್ಮೊಂದು ಆಫರ್ ಬಂದಿದೆ, ರೈಟ್? ಯು ಕ್ಯಾನ್ ಕ್ಯಾನ್ಸಲ್ ಇಟ್. ಸೊ ಕ್ಯಾನ್ಸಲ್ ಹೆಂಗೆ ಮಾಡಬೇಕು? ರಿವೋಕೇಶನ್ ಆಫ್ ಆಫರ್. ಆಫರ್ ಹೆಂಗೆ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ತಾರೆ, ರೈಟ್? ಸೊ ದ್ಯಾಟ್ ವಿಲ್ ಡಿಸ್ಕಸ್ ನಾ ಟುಡೇ. ನೋಡಿ, ಈಗ by notice of revocation, we are sending the notice to the cancel the offer. A offered B to sell the goods of 50,000. Who has offered here? A has offered, right? To whom? B. Through post. But before B could accept it, the offer, B could accept the offer, A received highest bid from the goods from C. So he revoked the offer by informing B over the telephone and sold the goods to C. So bacho, here what we can see is that, assume that you are offered something to somebody XYZ. Okay? Before his acceptance, remember, before his acceptance, you can cancel the offer. Remember one thing, whatever the offer you are going to send, whatever the offer you have proposal to the offeree, you can cancel. When you can cancel? Before the offer is accepted. Once the offer is accepted, it's nothing but gunpowder having matchstick. We have just sparked the gunpowder now. Got it? Got it, bacha? Hello? ಯಾ, ಹೌದ್ರಿಪ್ಪ. ಅದು ಸ್ವಲ್ಪ ಅವ್ರಿಗೆ ಹೇಳಿದ್ದೀನಿ ನಾನು, ಅವರು ಕೇಳಿಲ್ಲ ಬಿಟ್ಟಿಲ್ಲ. ಅದು ಹೋಲ್ಡ್ ಮಾಡಕ್ಕೆ ಬರುತ್ತಾ ಒಂದು ದಿವಸ ಬೈ ಈವ್ನಿಂಗ್ ತನಕ? ಹಾಂ ಸರ್. ಇಲ್ಲ, ಹೇಳಿಬಿಡಿ, ರಿಟರ್ನ್ ಕಳಿಸ್ಬಿಡಿ ಅಂತ. ಅವ್ನಿಗೆ ಹೇಳಿದೆ ನಾನು, ಹೋಲ್ಡ್ ಮಾಡಪ್ಪ ಸ್ವಲ್ಪ ಅಂತ. ಅವ್ನಿಗೆ ಸಮಾಧಾನ ಇಲ್ಲದ ಕಳಿಸ್ಬಿಟ್ಟದೆ ನಾವು. ಅವ್ನಿಗೆ ಆ್ಯಕ್ಚುಲಿ ನಂದು ಬೇರೆ ಕಮಿಟ್ಮೆಂಟ್ ಇತ್ತು ಸರ್, ಅದು ಅವಾಗ ಹೇಳಿದೆ ನಾನು. ಲೆಟ್ ಇಟ್ ಬಿ, ಕಳಿಸ್ಬೇಡಿ, ನಾನು ಅಕೌಂಟ್ ಪೇ ಮಾಡಿಬಿಡ್ತೀನಿ. ಸೊ ಗೈಸ್, ಲೆಟ್ಸ್ ಬಿಗಿನ್ ನೌ. ನೋಡಿ, ಈಗ ಆಫರ್ acceptance ಆಗೋಕ್ಕಿಂತ ಮುಂಚೆ, ಬಿಫೋರ್ ದ ಆಫರ್ is accepted, we can revoke the offer by sending what bacha? By sending notice. We can send the notice to him and we can cancel it. ಅಂದ್ರೆ ಏನು ಸರ್? by notice of revocation ಏನಾಗುತ್ತೆ? A offered B to sell goods 5,000 through the post, but before could accept, notice this is a very important, before B could accept the offer, A received highest bid through the C. He got more price, like maybe more than 5,000. So A revoked the offer by informing through telephone, because he has sent through post, right? Before reaching this post to the B, he has called and he said, no, I don't want to sell. Got it? ಸೊ ದಿಸ್ ಕಾಲ್ಡ್ ಬೈ ನೋಟಿಸ್ ಆಫ್ ರಿಯೋಕೇಶನ್. ಬೈ ನೋಟಿಸ್ ಆಫ್ ರಿಯೋಕೇಶನ್ ಆಗುತ್ತೆ. ಅರ್ಥ ಆಗಿದೆಯಾ? ಅಂಡರ್ಸ್ಟುಡ್? ಸರ್ ನೆಕ್ಸ್ಟ್ ಏನು? ನೆಕ್ಸ್ಟ್ ನೋಡಿ ಬೈ ಲ್ಯಾಬ್ಸ್ ಆಫ್ ಟೈಮ್. ಲ್ಯಾಬ್ಸ್ ಆಫ್ ಟೈಮ್ ಅಂದರೆ ಆಫರ್ ಇದೆ, ಒಂದು ಆಫರ್ ಮಾಡಿದ್ದೀವಿ, ಆಫರ್ ಕಳಿಸಿದ್ದೀವಿ, ಒಂದು ಟೈಮ್ ಇದೆ ಇದಕ್ಕೆ, ವಿದಿನ್ ದ ಟೈಮ್ ವಿ ಹ್ಯಾವ್ ಟು. ಇಲ್ಲಪ್ಪ ಅಂದರೆ ಎಸ್ ಬಚ್ಚು, ದ ಟೈಮ್ ಫಾರ್ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಕ್ಯಾನ್ ಬಿ ಲ್ಯಾಬ್ಸ್ ಇಫ್ ದ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಇಸ್ ನಾಟ್ ಗಿವನ್ ವಿದಿನ್ ಅ ಸ್ಪೆಸಿಫೈಡ್ ಪೀರಿಯಡ್ ಆಫ್ ಟೈಮ್. ಅಂದ್ರೆ ಏನ್ರಿ ಸರ್? ಈಗ ನೋಡಿ, ಸ್ಪೆಸಿಫೈಡ್ ಪೀರಿಯಡ್ ಆಫ್ ಟೈಮ್ ಅಂದ್ರೆ ಸ್ಪೆಸಿಫೈಡ್ ಟೈಮ್ ಇದೆಯಲ್ಲ, ದಟ್ ಮೇ ಬಿ ಆಫರ್ದಲ್ಲಿ ಹೇಳಿರ್ಬೋದು ನಾವು. ಗಾಟ್ ಇಟ್? ಆಫರ್ದಾಗ ಸ್ಪೆಸಿಫೈ ಮಾಡಿರ್ಬೋದು. ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ದೇರ್ ಇಸ್ ಎ ರೀಸನೇಬಲ್ ಟೈಮ್. ಆ ರೀಸನೇಬಲ್ ಟೈಮ್ ಒಳಗಡೆ ನೀವು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಬೈ ಡಿಫಾಲ್ಟ್ ಏನಾಗುತ್ತೆ? ಆಫರ್ ಏನಾಗುತ್ತೆ ಬಚ್ಚು? ಕ್ಯಾನ್ಸಲ್ ಆಗಿಬಿಡ್ತದೆ, ರಿಯೋಕ್ ಆಗುತ್ತೆ. ಗಾಟ್ ಇಟ್ ಮೈ ಡಿಯರ್ ಸ್ಟೂಡೆಂಟ್? ಅಂದ್ರೆ ಏನು ಸರ್? ಈಗ ದ ಟೈಮ್ ಫಾರ್ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಕ್ಯಾನ್ ಬಿ ಲ್ಯಾಬ್ಸ್ if the acceptance is not given within a specified time, right? And where no time is specified, ಎಲ್ಲಿ ಆಫರ್ ದಾಗ ಟೈಮ್ ಸ್ಪೆಸಿಫೈ ಮಾಡಿಲ್ಲಪ್ಪ ಅಂದ್ರೆ, then within a reasonable time, right, the offer can be lapse. ಗೊತ್ತಾಗಿದೆಯಾ? right? So this is the reason for that proposal should not made to wait indefinite time. ಯಾರಿಗೆ ಪ್ರಪೋಸ್ ಮಾಡಿರ್ತಾರಲ್ಲ ಅವರು ವೇಟ್ ಮಾಡಕ್ಕೆ ಹೋಗಬಾರ್ದು indefinite time. You should have some certain limit, right? It was held in case of Ramsgate Victoria Hotel versus Montefiore. that ಏನಾಗಿತ್ತಂದ್ರೆ ನೋಡಿ, ಟೈಮ್ ಇದೆ, ಒಂದು ಲಾಸ್ಟ್ ಆಫ್ ಟೈಮ್ ಅಂದ್ರೆ ಹೋಗ್ಬಿಡ್ತದೆ. who applied for share in June was not bound by allotment made in the November. ಅಪ್ಲೈ ಆಗೋಣ ನಾವು ಶೇರ್ಸ್ ಜೂನ್ ಅಪ್ಲೈ ಮಾಡೋಣ, ಬಟ್ ಅಲಾಟ್ಮೆಂಟ್ ಇನ್ನೂ ಆಗಿಲ್ಲ. ಎಲ್ಲಿ ಆಗಿಲ್ಲ? ನವೆಂಬರ್ದಾಗ. ದಿಸ್ ಡಿಸಿಷನ್ ವಾಸ್ ಆಲ್ಸೋ ಫಾಲೋಡ್ ಇನ್ ಇಂಡಿಯನ್ ಕೋಆಪರೇಟಿವ್ ನೇವಿಗೇಷನ್ ಅಂಡ್ ಟ್ರೇಡಿಂಗ್ ಕಂಪನಿ ವರ್ಸಸ್ ಪದ್ಮಶ್ರೀ ಪ್ರೇಮ್ಜಿ. However, these decisions now will have no relevance in the context of allotment of shares since Companies Act 2013 ನಲ್ಲಿ ಬಂದಿದೆ. ಬಿಕಾಸ್ ಕಂಪನಿ ಆಕ್ಟ್ 2013 ಅಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ ಇಷ್ಟು ದಿವಸ ಒಳಗಡೆ ಶೇರ್ಸ್ ಅಲಾಟ್ ಮಾಡಬೇಕಂತ. ಬಟ್ ದೇರ್ ಇಸ್ ಸಮ್ ಸ್ಪೆಸಿಫೈಡ್ ಟೈಮ್ ಇರುತ್ತೆ, ರೈಟ್? ಸ್ಪೆಸಿಫೈಡ್ ಟೈಮ್ ಒಳಗೆ ಬಿಕಾಸ್ ಏನಾಗುತ್ತೆ ಕೇಳಿ, ವಾಟ್ ಹ್ಯಾಪನ್ಸ್ ಇಸ್ ದಟ್ ಬಚ್ಚಾ, ಒಂದು ಕಂಪನಿ ಇದೆ ಈಗ, ಕರೆಕ್ಟ್? ಕಂಪನಿ ಇದೆ, ಈ ಕಂಪನಿ ಶೇರ್ಸ್ ಇಶ್ಯೂ ಮಾಡುತ್ತೆ, ಕರೆಕ್ಟ್? ಈಗ ಶೇರ್ ಹೋಲ್ಡರ್ಸ್ ಅಪ್ಲೈ ಮಾಡ್ತಾರೆ, ರೈಟ್? ಅಪ್ಲೈ ಮಾಡಿದ ಮೇಲೆ ಕಂಪನಿ ಹತ್ರ ಆಫರ್ ಇರ್ತದೆ, ಅದು ಕಂಪನಿ ಹತ್ರ ಆಪ್ಷನ್ ಇರುತ್ತೆ, ಅದನ್ನ ಆಕ್ಸೆಪ್ಟ್ ಮಾಡಬೇಕು ಇಲ್ಲ ಅಂತ. ಒನ್ಸ್ ದ ಕಂಪನಿ ಆಕ್ಸೆಪ್ಟೆಡ್ ದಟ್ ಮೀನ್ಸ್ ಅಲಾಟೆಡ್, ಹೌದಿಲ್ಲ? ಶೇರ್ಸ್ ಹ್ಯಾವ್ ಬೀನ್ ಅಲಾಟೆಡ್. ಈ ಅಲಾಟ್ಮೆಂಟ್ ಪ್ರೊಸೆಸ್ ಇದೆಯಲ್ಲ, ದಟ್ ಹ್ಯಾಸ್ ಸರ್ಟನ್ ಟೈಮ್. ಸೊ ಇವ್ರು ಮುಂಚೆ ಹೆಂಗಿತ್ತು, ಕಂಪ್ನೀಸ್ ತೆಗೆದ್ರೆ ಓನ್ ಟೈಮ್, ಅವಾಗ ಅದು ಕೇಸ್ ಆಗಿತ್ತು. ಬಟ್ ಏನಾಗುತ್ತೆ, ರೀಸನೇಬಲ್ ಟೈಮ್ ಇದೆ, ಒಂದು ಕೆಲಸ ಆಗಿ ರೀಸನೇಬಲ್ ಟೈಮ್ ಇದೆ, ಹೌದು ಇಲ್ಲ? ಈಗ ಉದಾಹರಣೆಗೆ ಎಕ್ಸಾಂಪಲ್, ಇಲ್ಲೇ ಎ ಅದಾನೆ, ಇಲ್ಲೇ ಬಿ ಅದಾಳೆ, ಇವರಿಬ್ರು ಬಾಯ್ ಫ್ರೆಂಡ್ ಗರ್ಲ್ ಫ್ರೆಂಡ್ ಅದಾಳೆ, ದೇ ಆರ್ ಲವಿಂಗ್ ಈಚ್ ಅದರ್. ಬಟ್ ಈಕಿ ಆಫರ್ ಕೊಟ್ಟಾಳೆ ನಿಮ್ಗೆ ಮದ್ವೆ ಮಾಡ್ಕೋ ಅಂತ, ಇವ ತಡಿ ಅಂದ್ರ ದೇರ್ ಇಸ್ ಸಮ್ ಟೈಮ್, ರೈಟ್? ಈಕಿಗೆ ಅವ್ರ ಮನ್ಯಾಗ ಪೇರೆಂಟ್ಸ್ ಫೋನ್ ಮಾಡಿ, ಚೆನ್ನಾಗಿ ಗಂಡ ಹುಡುಗನ ಮದುವೆ ಮಾಡ್ಕೊಂಡು, ಶಿ ನೋ ದಟ್ ಬಾಯ್ ಅಂಡ್ ಶಿ ಮ್ಯಾರೇಜ್. ಬಿಕಾಸ್ ಆಫರ್ ಇತ್ತು, ಆಕ್ಸೆಪ್ಟೆನ್ಸ್ ಟೈಮ್ ಇತ್ತಲ್ಲ, ಆಮೇಲೆ ಕೇಸ್ ಆಗಿ ಬರ್ತದನ ಇಲ್ಲ, ಹೋಗ್ಬಿಟ್ಟಡಕ್ಕಿ ಮುಗೀತ. ಸೊ ಅಂದ್ರೆ ಏನಾಗುತ್ತೆ ಬಚ್ಚು, ಎಲ್ಲಕ್ಕೂ ಒಂದು ಟೈಮ್ ಇರ್ತಲ್ಲ, ದಟ್ ಇಸ್ ವಾಟ್. ಇಫ್ ದ ಟೈಮ್ ಕ್ರಾಸ್ ರಿಯೋಕೇಶನ್ ಆಗುತ್ತೆ, ರೈಟ್? ಇಫ್ ದ ಟೈಮ್ ಕ್ರಾಸ್ ದ ರಿಯೋಕೇಶನ್ ಆಗುತ್ತೆ. ಆಲ್ ರೈಟ್ ಬಚ್ಚು. ಬೈ ನಾನ್ ಫುಲ್ಫಿಲ್ಮೆಂಟ್ ಆಫ್ ಕಂಡೀಷನ್ ಪ್ರೆಸಿಡೆಂಟ್, ಈಗ ಅಂದ್ರೆ ಏನ್ ಸರ್? ಈಗ ಕಂಡೀಷನ್ ಪ್ರೆಸಿಡೆಂಟ್ ಅಂದ್ರೆ ಏನು? where the acceptor fails to fulfill the condition precedent to accept, the personal proposal gets by default revoke ಆಗ್ಬಿಡುತ್ತೆ. ಈ ಕ್ವಶನ್ ಏನು ಸರ್ ಅಂದ್ರೆ ನೋಡಿ, ಈಗ one example, suppose where A proposes to sell his house to B for 5 lakh, provided B leases his land to A. If B refuses to lease the land, the offer of A is revoked automatically. ಹೌದಲ್ಲ? ಸೊ ಅಂದ್ರೆ ಈಗ ಕಂಡೀಷನ್ ಟು ದ ಪ್ರೆಸಿಡೆಂಟ್, ಆಫರ್ಗಿಂತ ಮುಂಚೆ ಏನಪ್ಪಾ ಅಂದ್ರೆ, ವೇರ್ ದ ಅಕ್ಸೆಪ್ಟರ್ fails to pay, fails to fulfill the conditions precedent to the acceptance ಮುಂಚೆ ಅದು condition satisfy ಆಗಲ್ಲ ಆಗುತ್ತೆ. This principle is laid down in section 6 of the Indian Contract Act. ನೆನಪಿಟ್ಕೊಳ್ಳಿ, section 6 of the Indian Contract Act ಏನಂದ್ರೆ, the offerer for instance may impose certain condition such as executing certain documents or depositing certain amount as earnest money. ಡೌನ್ ಪೇಮೆಂಟ್ ಕೊಡಬೇಕಾಗುತ್ತೆ, ಡಾಕ್ಯುಮೆಂಟ್ ಸಬ್ಮಿಟ್ ಮಾಡಬೇಕಾಗುತ್ತೆ, ರೈಟ್? ಅವನು ಇದೆಯಲ್ಲ ಅಂತ ಕನ್ಫರ್ಮ್ ಮಾಡ್ಕೋಬೇಕಾಗುತ್ತೆ. ಫೇಲ್ಯೂರ್ ಟು ಸ್ಯಾಟಿಸ್ಫೈ ಎನಿ ಕಂಡೀಷನ್ ವಿಲ್ ರಿಸಲ್ಟ್ ಇನ್ ಲ್ಯಾಪ್ಸ್ ಆಫ್ ಆಫರ್. ಆಬ್ವಿಯಸ್ಲಿ ಅಲ್ಲ. ಈಗ ನಾವು ಹೇಳಿದ್ವಿ, ಈಗ ಇಫ್ ಐ ಸೇ ಸಮಥಿಂಗ್ ಲೈಕ್ ನಮ್ಮ ಜಾಬ್ ಕೊಡ್ತಾ ಇದ್ದೀವಿ, ನಾವು ಆಫರ್ ಕೊಡ್ತಾ ಇದ್ದೀವಿ, ಕಂಡೀಷನ್ ಏನು? ನಿಮ್ದು ಈ ಕ್ವಾಲಿಫಿಕೇಶನ್ ಆಗಿರಬೇಕು, ನೀವು ಹೇಳ್ತಾರಲ್ಲ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಆಗಿದೆ, ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡಬೇಕಾಗುತ್ತೆ. ಈಗ ನೀವು ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟೇ ಇಲ್ಲ, ನಮ್ದು ಆಫರ್ನ ಆಕ್ಸೆಪ್ಟ್ ಮಾಡಿದ್ರೆ ಲ್ಯಾಪ್ಸ್ ಆಗುತ್ತದು, ಹೌದು ಇಲ್ಲ? ಈಗ ಏನಾಯ್ತಪ್ಪ ಅಂದರೆ, ಯು ಗಾಟ್ ಪ್ಲೇಸ್ ಇನ್ ಗೂಗಲ್, ಆಫರ್ ಸಿಕ್ಕೈತೆ ನಿಮಗೆ ಗೂಗಲ್ದಾಗ, ಹಾಂ, ಆ ಆಫರಿಗೆ ಆಕ್ಸೆಪ್ಟ್ ಮಾಡಬೇಕು. ಬಟ್ ಬಚ್ಚೋ ಪ್ರೆಸಿಡೆಂಟ್ ಕಂಡೀಷನ್ ಪ್ರೆಸಿಡೆಂಟ್ ಏನಿದೆ, ಆಫರ್ ಜಾಯಿನ್ ಆಗೋಕ್ಕಿಂತ ಮುಂಚೆ ನಿಮ್ಮದು ಸರ್ಟಿಫಿಕೇಶನ್, ನಿಮ್ದು ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಸಬ್ಮಿಟ್ ಮಾಡಬೇಕು. ಅಕಸ್ಮಾತ್ ಸಬ್ಮಿಟ್ ಮಾಡಿಲ್ಲ ಅಂದರೆ ಗೂಗಲ್ದ ಆಫರ್ ಏನಾಗುತ್ತೆ, ರಿಯೋಕ್ ಆಗ್ಬಿಡ್ತೈತೆ, ರೈಟ್? ಹೌದಲ್ಲ? So the offer for instance may impose certain conditions such as executing certain documents or depositing certain amount as earnest money. Failure to satisfy any condition result in lapse of proposal, right? As stated earlier, conditions precedent offer ginta munchedu to accept the prevent an obligation from the coming into existence until the condition is satisfied. Condition satisfy ಆಗೋ ತನಕ ಆಫರ್ ಅಕ್ಸೆಪ್ಟ್ ಆಗಂಗಿಲ್ಲ, ಕಂಡೀಷನ್ ಸಾಟಿಸ್ಫೈ ಆಗೋ ತನಕ ಕಂಪ್ಲೀಟ್ ಆಗೋದಿಲ್ಲ ಆಫರ್, ರೈಟ್? ಅರ್ಥ ಆಗಿದೆಯಾ? ಅಂಡರ್ಸ್ಟ್ಯೂಡ್? ಮುಂದೋಗೋಣ. ಸೊ ನೆಕ್ಸ್ಟ್ ಏನು ಸರ್? ಈಗ ನೆಕ್ಸ್ಟ್ ಬೈ ಡೆತ್ ಆರ್ ಇನ್ಸ್ಯಾನಿಟಿ. ಇದಾದ್ಮೇಲೆ ಡೆಫಿನೆಟ್ಲಿ ಬಚ್ಚು ವಿಲ್ ಸ್ಟಾರ್ಟ್ ದ ಕೇಸ್ ಸೀರೀಸ್ ನಾವು. ಬೈ ಡೆತ್ ಆರ್ ಇನ್ಸ್ಯಾನಿಟಿ, ಈಗ ಯಾರಿಗೆ ಆಫರ್ ಮಾಡಿರಿ, ಆಫರ್ ಮಾಡಿದವ್ರು ಸತ್ತೋದಂದ್ರೆ ಬೇಕಾಗುತ್ತೆ, ಹೌದಲ್ಲ? ಇನ್ಸ್ಯಾನಿಟಿ, death or insanity of the proposer would result in automatically revocation of proposal, but only if the fact of death or insanity comes to knowledge of acceptors. Acceptor ಗೊತ್ತಾದ ಮ್ಯಾಗ ಅಷ್ಟ ಆಗೋದು, ರೈಟ್? ಬೈ ಕೌಂಟರ್ ಆಫರ್ ಮ್ಯಾಗ ಆಫರ್ ಕೊಟ್ಟರೆ ನೀವು ಏನಾಗುತ್ತೆ, ಆಫರ್ ಕ್ಯಾನ್ಸಲ್ ಆಗುತ್ತೆ. ಬೈ ನಾನ್ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಆಫ್ ದಿ ಆಫರ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ದ ಪ್ರಿಸ್ಕ್ರೈಬ್ಡ್ ಆರ್ ಯೂಶುವಲ್ ಮೋಡ್, ಆಫರ್ ಕ್ಯಾನ್ಸಲ್ ಆಗುತ್ತೆ, ಹೌದಲ್ಲ? ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಇಲ್ಲಿಗಾಲಿಟಿ, ಆಫರ್ ಇಲ್ಲಿಗಲ್ ಇದ್ರೆ ಡೆಫಿನೆಟ್ಲಿ ಬಚ್ಚು. ಸೊ ಹಾಗಿದ್ರೆ ಲೆಟ್ಸ್ ಡಿಸ್ಕಸ್ ಸಮ್ ಇಂಪಾರ್ಟೆಂಟ್ ಕ್ವಶನ್ಸ್ ನಾವು, right? And we'll finish this bacha. So bacho, here we have we'll discuss all this now, and these are the questions you can expect for your previous exam like kedidru, and similar questions you can expect for upcoming exams. Sir yenide keda maile, Ramaswamy proposed to sell his house to Ramnath. Ramaswamy what is doing? He's selling house to Ramnath. Ramnath sent his acceptance by post. Ramaswamy sell his proposed offer has from Ramaswamy to Ramnath, right? And Ramnath sent his offer. Sorry, Ramnath sent his acceptance by post next day, because there is a Ramaswamy who he may send offer by post only, or maybe anything, but he got an offer. Who got an offer here? Ramnath. Who has offered here? Ramaswamy. Ramanath replied saying that yes, I'll accept your offer, and he sent it by post. He has sent it by post. Next day, immediate next day, Ramnath sent a telegram which is faster than the post. Okay, withdrawing his acceptance. In acceptance illa, he is cancelling here. Il nodi, Ramaswamy when Ramanath accepted, that means he is by default bond again. Bond agbidutte. He has to what? He has to perform it. He cannot revoke the offer, right? Because when he sent offer to Ramnath, definitely when the Ramnath accepted the offer, that means that's it. Contract start agbidutte. He has to perform. But in case of offeree, in case of Ramnath, he has two options. He can reject the offer or he can accept the offer. when he has accepted the offer, even he has option. What option he has? He can revoke the acceptance by sending revocation before the acceptance is received to the Ramaswamy. Gottagidya? So next day Ramnath sent a telegram withdrawing his acceptances. So post, earlier than the post, telegram will reach, right? This is the first step. So examine validity of the acceptance according to Indian Contract Act 1872 in the light of the following. Acceptance though validity ಏನಾಗುತ್ತೆ. But so in case of Ramaswamy, he is helpful. It cannot be like. Tell me, Alok, what is doubt you have? So, bacha, what I'm saying is that first of all, Ramaswamy is completely by default bonded here, and Ramnath has two options. Whatever he has done right acceptance, he can done it, or he can reject the acceptance. Now, the telegram of revocation acceptance received by Ramaswamy before the letter of acceptances. See, revocation has been received. Revocation has been received before the acceptance. Yes, offer can be revoked here. Sorry, acceptance can be revoked here. Right? Second, the telegram of revocation and letter of acceptance both received. So again, both received at the same time means here the Ramaswamy who read first, that is accepted here. Obviously, we will go with the telegram because that goes more important, right? That is other side. We are talking about the Ramnath case here. Ramaswamy also there. Ramaswamy also, for Ramaswamy we have very less options. Nodi, very simple ಇದೆ. Ramaswamy offer ಕಳಿಸಿದ ಮ್ಯಾಗೆ ಇವ ಆಕ್ಸೆಪ್ಟ್ ಮಾಡಿಬಿಟ್ರೆ ಮುಗೀತು. ಆಕ್ಸೆಪ್ಟ್ಗಿಂತ ಮುಂಚೆ ಅವ ರಿವೋಕೇಶನ್ ಆಫರ್ ಕಳಿಸಬಹುದಾಗಿತ್ತು. ಯಾವುದು ಈ ಲೈನ್ ಮಾಡಕ್ಕೆ ಬರಂಗಿಲ್ಲ. ವಿ ಕೆನಾಟ್. ಅಂದ್ರೆ ವಾಟ್ ಯು ಆರ್ ಸೇಯಿಂಗ್ ಟ್ರೈಂಗ್ ಟು ಸೇ ಇಸ್ ದಟ್ ಈಗ ರಾಮಸ್ವಾಮಿ ಇದ್ದಾನೆ, ರೈಟ್? ಇಲ್ಲಿ ರಾಮನಾಥ್ ಅದಾನೆ, ಆಫರ್ ಕಳ್ಸಾನೆ, ಇವ ಆಫರ್ ಕಳ್ಸಾನೆ, ರೈಟ್? ಆಫರ್ ಕಳ್ಸಾನೆ, ಆಫರ್ ಇವ ಆಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಾನೆ. ಪ್ರಾಬ್ಲಮ್ ಇಸ್ ಡನ್ ಹಿಯರ್. ಕಾಂಟ್ರಾಕ್ಟ್ ಫಿನಿಶ್ ಆಗ್ಬಿಡ್ತು. That is what I'll explain that now. So, before this offer reaches to the Ramaswamy, if he send by telegram, he can cancel the offer. But our point is we are discussing about Ramnath. Ramnath, what he has done? First, what he has done, bacha, he has sent the acceptance by post. Again, he has sent what? Telegram for revocation. So, here what happens? He can, once telegram reaches to the Ramaswamy before acceptance, the acceptance can revoke. Correct? But if both reaches same time, in that case, Ramaswamy, whichever he read first, that is considered. If he read acceptance, that means contract is valid. If he reads revocation, contract is ends here. Got it? Got it, bachcho? Now, Kedri. As per the section, so this is how you have to write now. First, we have to write the explanation for this. As per the section 4 of the Indian Contract Act, that's what section is very important here. 1872, the communication of an acceptance is complete. Remember, the communication of acceptance is complete as against the acceptor when it comes to the knowledge of the proposer. Howdalla? Yes or no? ಯಾರಿಗೆ ಪ್ರಪೋಸ್ ಮಾಡ್ತೀರಿ ಕಮ್ಯುನಿಕೇಶನ್ ಆಫ್ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಕಂಪ್ಲೀಟ್ ಆಗುತ್ತೆ ಅವ್ನು ಗೊತ್ತಾದ್ರೆ. ಅಂದ್ರೆ ಇನ್ ದಿಸ್ ಕೇಸ್ ಬಚ್ಚು ರಾಮಸ್ವಾಮಿಗೆ ಗೊತ್ತಾಯಿತು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿದ ಅಂದ್ರೆ ಮುಗೀತು, ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಕಂಪ್ಲೀಟ್ ಆಗ್ಬಿಡ್ತೈತಿ. ಇಲ್ಲಿ ಕ್ವಶನ್ ಇಸ್ ದಟ್ Ramaswamy whether he knows or not. If he knows, offer is accepted become valid contract. If he doesn't know that his offer has not yet completed, again the situation arises. What situation arises, bacha? As per the section 4 of the Indian Contract Act 1872, the communication of offer is acceptance. Communication of an acceptance is complete as against acceptor when it comes to knowledge of the person who has offered, the proposer. This acceptance can be revoked. This acceptance can be revoked. Once they come to knowledge of the proposer, no, we cannot revoke. But prior to the acceptance, prior to the knowledge of proposer, prior to the knowledge of proposer, this can be revoked by the acceptance, before the acceptance of letter reaches to the proposer. Howdalla? Acceptance letter lagu munchi before that acceptance letter reaches to the offerer or proposer, we can cancel it. Got it? However, once the letter of acceptance reach, the proposer of the acceptance cannot be reached, cannot be revoked. One acceptance reach aitu, we cannot revoke it. Got it? We cannot revoke it. अर्थ ಆಗ್ತಾ ಇದೆಯಾ? ಅರ್ಥ ಆಗ್ತಾ ಇದೆ ಬಚ್ಚೋ? ನೆಕ್ಸ್ಟ್, ಈಗ ಕಂಡೀಷನ್ ಏನಪ್ಪ? ಪ್ರಪೋಸರ್ಗೆ ಗೊತ್ತಾಯಿತು, ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಮಾಡಿದಾನೆ, ಮುಗೀತು, ವಿ ಕ್ಯಾನಾಟ್ ರಿವೋಕ್ ಇಟ್. ಸೆಕೆಂಡ್, ಈಗ ನೀವು ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಕಳಿಸಿರಿ ಅವನಿಗೆ, ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ರೀಚ್ ಆಗಿದೆ, ಯಾರಿಗೆ? ಪ್ರಪೋಸರ್ಗೆ. ವಿ ಕ್ಯಾನಾಟ್ ರಿವೋಕ್. ಹಾ, ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ರೀಚ್ ಆಗೋಕ್ಕಿಂತ ಮುಂಚೆ ನೀವು ರಿವೋಕೇಶನ್ ಕಳ್ಸಾಕತ್ತೀರಾ, ಅವಾಗ ಚಾನ್ಸಸ್ ಇದೆ. Thus, whichever he received the first shall be valid. ಅಂದ್ರೆ ಈಗ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಇದೆ, ರಿವೋಕೇಶನ್ ಇದೆ. ಸೊ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಗಿಂತ ರಿವೋಕೇಶನ್ ಮುಂಚೆ ಬಂದ್ರೆ ರಿವೋಕೇಶನ್ ಆಯ್ತು, ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಮುಂಚಿದ್ರೆ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಆಗುತ್ತೆ. ಇನ್ ಕೇಸ್ he received both together, whichever he read first. In case ಎರಡು ಬಂದ ಅವನ ಕಡೆ, if in case he received both together, right, the one which he read first, he can. Now, ಅರ್ಥ ಆಗಿದೆಯಾ? ಇಷ್ಟು ಬರಿಬೇಕಾಗುತ್ತೆ. ನಾಟ್ ನೆಸೆಸರಿ ಸೇಮ್ ಟು ಸೇಮ್. ಇನ್ ಯುವರ್ ಲ್ಯಾಂಗ್ವೇಜ್ ಯು ಕ್ಯಾನ್ ರೈಟ್ ಇಟ್. ಇನ್ ಯುವರ್ ಲ್ಯಾಂಗ್ವೇಜ್ ಯು ಕ್ಯಾನ್ ರೈಟ್ ಇಟ್. ಅರ್ಥ ಆಗಿದೆಯಾ ಬಚ್ಚ? ಅಂಡರ್ಸ್ಟ್ಯೂಡ್? ಮುಂದೆ ಹೋಗೋಣ. ರೈಟ್ ನೌ, in the above case, Ramaswamy proposed to sell his house to Ramnath, right, and Ramnath sent his acceptance by post. Later he sent a telegram of revocation of his acceptance. Now the question, if the Ramnath received Ramaswamy's before the acceptance, in the telegram is what? Telegram is revocation. Received by Ramaswamy before the acceptance letter, the revocation is valid ಆಗುತ್ತದೆ. ಹೌದಲ್ಲ? Next, if both letter of acceptance and telegram of revocations reach together, whichever Ramaswamy read first shall be valid here. If he is reading acceptance, definitely the contract is completed. If he is reading telegram, offer acceptance is revoked. If the Ramaswamy opens the telegram first, and this would be normally in case of rational person, because obviously we are going to open the telegram first, rather post. So it read it and then acceptance stands for revocation. If he opens the letter first and reads it, revocation of acceptance is not possible and contract has already been concluded. ಈ ರೀತಿ ಬರಿಬೇಕಾಗುತ್ತೆ. ಅರ್ಥ ಆಗಿದೆಯಾ? ಅಂಡರ್ಸ್ಟ್ಯೂಡ್ ಬಚ್ಚೋ? ಹೇಳ್ರಿಪ್ಪ. Tell me guys. So these are the questions you can expect bachcho. I'm sure you'll get it. Next, all contracts are agreement. Yeah, but all agreements are not contract. Nodi, there are certain agreements which may be illegal, social, that cannot be considered as a contract. But as per the Indian Contract Act, all the agreement which is enforceable by law is contract. To fulfill, to complete an agreement, to become a contract, to become a valid contract, there should be agreement which is enforceable by law. Right? So that means what, sir? Now, they explained here, have a look here. So you have to write in this way. So an agreement comes into existence when one party makes a proposal or offer to other party. What is agreement? Promises or set of the promises forming consideration to each other. Right? When the promise is accepted, when the proposal is accepted, that is ಪ್ರಾಮಿಸ್ ಆಗುತ್ತೆ, ಹೌದಲ್ಲ? So an agreement comes into existence when one party makes proposal or offer to other party, and that other party gives his acceptance to it. ಗೊತ್ತಾಗಿದೆಯಾ? So a contract is nothing but ಬಚ್ಚು agreement which is enforceable by law. ಹೌದು ಇಲ್ಲ? Contract is nothing but an agreement which is enforceable by law. Yes or no? It means that to become a contract, agreement must give rise to legal obligation. Very important. To become a contract, an agreement must give legal obligation because it should have enforceability. If agreement has enforceability, yes, it is valid contract. Right? ಇದೇನಪ್ಪ ಇದು ಹಂಗಾತಲ್ಲೋ ಮರೆಯ. ಇಲ್ಲಿ ಹೀಟಿಗೆ ಆಗ್ತಾ ಇದ್ದು ಏನಂತ ಗೊತ್ತಾಗ ನನಗೆ. 1 second. One study. Right? So, bacha, if agreement is incapable of creating enforceability, if the agreement is enforceable by law, it is having what bacho gives rise to legal obligation. So legal obligation means contract. An agreement can be a contract. If any agreement which is not capable of creating enforceability, it is not a contract. Howdala? Like social agreements, like illegal agreements. There can be agreements which are not enforceable by law, such as social, moral, religious agreement, which is not going to create any enforceability. Howdala? Yes or no? So the agreement is wider term than contract here. Contract has limited to the agreement which is enforceability, agreement which gives rise to the legal obligation. But in reality, agreement has wider term, because in agreement we have legal obligation. In agreement there are so many other social, personal, immoral agreements also we have. Right? So that's why we can say agreement is wider term than the contract. So all the agreements need not necessarily become a contract, but all the contract shall always be agreement. Always must be agreement. Okay now? Understood? So all the agreements not contract. All the agreements not contract. When there is an agreement between parties, they do not intend to create any legal relationship, it is not a contract. All the contracts are agreement. For contract, there must be two things, right? Yes or no? Agreement and enforceability. If in agreement, for any contract, if there is an agreement which is enforceability, we can say it is contract is fulfilled. So thus, existing, if an agreement is prerequisite existence of the contract, therefore it is true to say that all the contracts are agreement. Thus we can say that there can be agreement without becoming contract, but we can't have contract without agreement. ಹೌದಲ್ಲ? ಇಷ್ಟಂತೂ ಬರಿಬೇಕಾಗತ್ತೆ. ಅರ್ಥ ಆಗಿದೆ ಬಚ್ಚಾ? ಅರ್ಥ ಆಗಿದೆಯಾ? ಸೊ ಈ ರೀತಿ ಬರಿಬೇಕಾಗತ್ತೆ. ನೆಕ್ಸ್ಟ್, ಮಿಸ್ಟರ್ ಜಾಯ್ owns a flat in building. He wanted to sell the flat number 101 to Roy. ಈಗ ಜಾಯ್ ಹತ್ರ ಒಂದು ಮನೆ ಇದೆ, ಎರಡು ಮನೆ ಇದಾವೆ. He has two houses. One house you want to sell, 101. Right? Now, to Roy, who is offerer here? Proposer is Joy and offer is Roy. Joy offered to sell his flat 101 to Mr. Roy. But Mr. Roy thought that Mr. Joy wanted to sell 102. Miscommunication. Consensus is not an Adam, right? It's not Adam. They are not understanding the offer in same thing and same sense. and said yes for the agreement. Considering the provision of the Indian Contract Act, discuss the validity of such a contract. It is void agbidutte. ಇದಕ್ಕೆ there is no free consent because whatever the offer they have sent, that has been not understanding the same thing in the same sense. Very simple. ಇಷ್ಟ ಬರಿಬೇಕು ಕೇಳಿ. ಇದು ಬರೆಯೋದು ನೆನಪಿರಬೇಕಾಗುತ್ತೆ. ಯು ಹ್ಯಾವ್ ಟು ರೈಟ್, ಯು ಶುಡ್ ನೋ ಹೌ ಟು ರೈಟ್ ದಿಸ್ ನೌ. ನೋಡಿ ಇಲ್ಲಿ ಸಿಂಪಲ್ ಆಗಿಲ್ಲ. ಆಸ್ ಪರ್ ದಿ ಸೆಕ್ಷನ್ 10 ಆಫ್ ದಿ ಇಂಡಿಯನ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಆಕ್ಟ್ 1872, ಒನ್ ಆಫ್ ದಿ ಎಸೆನ್ಷಿಯಲ್ ಎಲಿಮೆಂಟ್ಸ್ ಆಫ್ ದಿ ವರ್ಲ್ಡ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಆಗಿದೆ ಫ್ರೀ ಕನ್ಸೆಂಟ್. ಫ್ರೀ ಕನ್ಸೆಂಟ್ ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಕಾಂಟ್ರಾಕ್ಟ್ ಆಗೋದಿಲ್ಲ. ಆಗುತ್ತಾ? ಇಲ್ಲ. ಸೊ ಕನ್ಸೆಂಟ್ ಈಸ್ ಎಕ್ಸ್ಪ್ರೆಸ್ಡ್. Consent is express willingness or giving voluntary permission or agreeing to something in the same sense. Correct? Hello? Hanapa? ಒಂದು ನಿಮಿಷ ನಾ ಕ್ಲಾಸ್ ಆಗಿದೆ ಕಾಲ್ ಮಾಡ್ತೀನಿ ನಿಮಗೆ. देखो चलो ಹ್ಯಾಂಗ್ ಆಗ್ತಾ ಇದೆ, ಕಟ್ ಆಗ್ತಾ ಇದೆ. So बच्चों, section 13 furtherly clears that two or more persons are said to be consent when they agreed upon same thing in the same sense. So when both the parties do not agree the same thing in same sense, the contract is completely void. Right? So in the present case, Mr. Joy, who owns 2 flats, wanted to sell 1 flat, that is 1/1, to Mr. Roy. On the other hand, Mr. Roy agreed to purchase thinking that he will buy the other flat, the one which is not offered. So here both the parties have given free consent, but they are not consenting for the same thing in the same sense. Right? So hence both the parties did not have mutual consent for contract. Therefore it is not a valid contract. ಅರ್ಥ ಆಗಿದೆಯಾ? Understood? ಚಲೋ. Define offer, essentials of valid offer. How offer is different from invitation to offer. ನೋಡಿ ಇದು ಕೂಡ ಇಂಪಾರ್ಟೆಂಟ್ ಇದೆ, ನಾನು ಡಿಸ್ಕಸ್ ಮಾಡೋಣ. Right? So it's a revision kind of stuff, right? Yes, every unit have a revision ಇರ್ತದೆ. ಸ್ವಲ್ಪ ನೋಡಬೇಕಾಗುತ್ತೆ ನಾವು. ನೋಡಿ offer has defined under section 2 subsection A of Indian contract. When one person signifies to another his willingness to do or abstain from doing anything with a view to obtain the assent of that other to such act or abstentions, he is said to make a proposal. Right? So bachcho, the essentials of offer must be capable of creating legal relationship, must be certain, definite, not vague, must be communicated, must be made. ಇದು ಪಾಯಿಂಟ್ಸ್ ಬರೀಬೇಕು ಹಿಂಗ, ಇದು ಮೀನಿಂಗ್ ಅಂತ ಬರೀಬೇಕು, ಪಾಯಿಂಟ್ಸ್ ಡೀಟೇಲ್ದಲ್ಲಿ ಬೇಡ. ಇಫ್ ಯು ರೈಟ್ ದಿಸ್ ಒನ್ ಜಾಸ್ತಿ ಮೋರ್ ದೆನ್ enough. Must be communicated, must be made with a view to obtain the assent of other party, may be conditional, offer should not contain terms non-compliance of which would amount to acceptance. Right? May be general or specific offer irbodu. Offer can be express or implied irbodu. A statement of price is not offer.
So what's the difference between conditional and both doesn't sound same? May be conditional and offer should not contain terms.
Yeah, offer may be conditional. Conditional in the sense, say, if you are going to accept in this way, then only offer is fulfilled here.
And it is also a term only, no?
Where is the term here? In offer, we don't have, yeah, it can be a terms and condition, right? Non-compliance is not should be there. Non-compliance, which because offer should not contain terms the non-compliance. Compliance ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಬರಂಗಿಲ್ಲ ಅದೇ. ಕಂಪ್ಲೈನ್ಸ್ ಫಾಲೋ ಮಾಡಬೇಕು, ರೈಟ್? ಈಗ ಆಫರ್ ಇದೆಯಲ್ಲ, ಆಫರ್ ನಾವು ಕೊಡ್ತಾ ಇದೀವಿ, ಈ ರೀತಿ ಹಿಂಗಿದ್ರೆ ಆಗುತ್ತೆ. ನೀವು CA ಫೌಂಡೇಶನ್ ಪಾಸ್ ಆಗಿರಿ, ಆಫರ್ ಆಕ್ಸೆಪ್ಟ್ ಮಾಡಿರಿ, ಬಟ್ ಕಂಡೀಷನ್ ಇಸ್ ದಟ್ you have to read, we will teach, you have to attend the classes. This is the offer accepted, right? Without attending the classes, without reading home, without practicing, you cannot pass CA foundation. That's what. So these are the essentials of offer, bacho. Now the question is that offer and invitation to offer, difference you should know. Iga offer and invitation to offer ನೆನಪಿಟ್ಟುಕೊಡ್ರಿ, and try to go home and write it once again. I'll share the PDF. I have another person. Offer means final expression of willingness by offerer to be bound by the offer should other party choose to accept it. That is offer. On the other hand, offers made with intention to negotiate. ಗೊತ್ತಾಯ್ತು ನಿಮಗೆ? Offer made with intention to negotiate or offer to receive offer. Offer that are going to have one more offer is known as invitation to offer. Last class ಹೇಳಿಲ್ಲ ನಿಮಗೆ, offer is nothing, invitation to offer is precedent to the offer ಆಗುತ್ತದೆ. Offer accept ಮಾಡೋಕ್ಕಿಂತ ಮುಂಚೆ invitation to offer ಆಗುತ್ತೆ. So offer is made with the object to getting the consent of offering, whereas invitation to offer is made with intention to get offer from the other person. ಹೌದಲ್ಲ? ಆಫರ್ ನಾವು ಕೊಡಾಕ್ತೀವಿ ಇದಕ್ಕೆ acceptance ಸಿಗ್ಲಿಪ್ಪ ಅಂತ, so that we get the acceptance. Whereas invitation to offer is nothing but we are inviting the offer to get the offer. Hodala? Yes or no? An offer can be accepted by offeree. Offer can be accepted by offeree. Whereas an invitation to offer cannot be accepted by the person to whom it is made. Because invitation to offer is going to create offer. Offer can be accepted here. But invitation to offer cannot be accepted, right? So offer when accepted become agreement. Yes or no? When offer it is become accepted, it is agreement. An agreement should form consideration to each other. Invitation to offer cannot be accepted at all, right? A shopkeeper displays a pair of dress in showroom and price tag of 2000 was attached to dress. Mr. Lovely looked at the tag and rushed into the cash counter. Then she asked the shopkeeper to receive the payment and pack the dress. The shopkeeper refused to hand over the dress to Mr. Lovely. Mrs. Lovely. Consideration of the price. She is ready to pay that, but in spite of that, she is not ready. State the price tag attached to the dress, right? Consideration state in the price tag. Miss Lovely seek your advice whether she can sue the shopkeeper for the above cause. Why? Because price tag quotation is invitation to offer. If you accept invitation to offer, it is not at all offer, agreement only. If offer is agreement accepted, then it can be agreement, which is going to be enforceable. Bacho, very simple, very easy, right? As per the provision of Indian Contract Act 1872, person making an invitation to offer does not make offer. Person make an offer, right? Person making an invitation offer does not make an offer. Rather, it's invite other party to make an offer here. We are going to ask him to make an offer. The objective of invitation is to show his willingness to deal with any person who on the basis of this ready, right, invitation is ready to enter into contract. ಅಂದ್ರೆ ಏನಾಗುತ್ತೆ, ಈಗ ಇನ್ವಿಟೇಷನ್ ಅಂತ ಕೊಡ್ತಾ ಇದೀವಿ, ಯಾರು ಬೇಕಾದ್ರೆ ಈ ಇನ್ವಿಟೇಷನ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿ ಬರಬಹುದು, ಆಫರ್ ಕೊಡಬಹುದು. Got it? In the case of Hari versus Facey, the privacy concept is there that we discussed. In the above case, Dress was displayed at a shop window with price tag. It is invitation to offer. It is not offer. Miss Lovely intended to buy it, make a payment, and ask the shopkeeper to pack it. The shopkeeper refused to sell it as the price tag on dress material was just an invitation to offer. The shopkeeper was not bound to sell the dress to Miss Lovely on her offer to buy it. So, Mr. Lovely cannot sue the shopkeeper. ಅರ್ಥ ಆಗಿದೆಯಾ? ಅರ್ಥ ಆಗಿದೆ? ನೆಕ್ಸ್ಟ್ ಹೇಳ್ರಿ. ಏನಪ್ಪ ಇದು ಹ್ಯಾಂಗ್ ಆಗ್ತಾ ಇದೆಯಲ್ಲ ಇದೊಂದು. ऑफ करो, ऑन करो. वो नहीं वो कैमरे का तड़ीपा. There is some problem, बच्चा. 1 second. बनता है ಇವಾಗ now is good. ಸ್ವಲ್ಪ ಆಗಲಿಲ್ಲ. ನಾವು ಕೊಟ್ಟಿದ್ದಿಲ್ಲ ಈಗ. ಚಲೋ result may be 7th this month. ಇಲ್ಲ CA foundation today. ಅಯ್ಯೋ ಚಲೋ you may get result ಬಚ್ಚ today. ಮತ್ತೆ ಹ್ಯಾಂಗ ಆತಲ್ಪ ಇದು? ಏನು ಮರ ಇದು?
No lies, sir. It was proper when you were live. Live correct ತಕ್ಷಣ ಆಗೋದಿಲ್ಲ.
ಹಾಗಿರಂಗಿಲ್ಲ ಅದು. ದಟ್ ಈಸ್ ನಾಟ್ ದ ಕೇಸ್. ಇದು ಪ್ರಾಬ್ಲಮ್ ಹ್ಯಾಂಗಾಗ್ತಾ ಇದೆ ನೋಡ್ರಿ. Shambhu Daya started self-service system in the shop. Means you can just go and buy anything, right? You need to pay the price. Srimati Prakash entered into the shop and took a basket, and after taking the article on her choice into the basket, reaches the cash counter. The cashier refused to accept the price. Can Shambhu Dayal be compelled to sell the said article to Srimati? No. Decide as per the provision of the Indian contract. ಏನಪ್ಪ ಅಂದರೆ ಸ್ವಲ್ಪ ಕೇಳಿ. ಆಸ್ ಪರ್ ದಿ ಪ್ರೊವಿಷನ್ ಆಫ್ ಇಂಡಿಯನ್, ಬಿಕಾಸ್ ನೋಡಿ ಇದು ಕೂಡ ಏನಾಗುತ್ತೆ ಇನ್ವಿಟೇಷನ್ ಆಫರ್ ಆಗುತ್ತೆ, ಪ್ರೈಸ್ ಹಾಕಿದೆ ಅಲ್ಲಿ. ಸೊ ಆಸ್ ಪರ್ ದಿ ಇಂಡಿಯನ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಆಕ್ಟ್ 1872, ಅ ಪರ್ಸನ್ ಮೇಕಿಂಗ್ ಎನ್ ಇನ್ವಿಟೇಷನ್ ಟು ಆಫರ್ ಡಸ್ ನಾಟ್ ಮೇಕ್ ಆಫರ್ ಅಟ್ ಆಲ್. ಅ ಇನ್ವಿಟೇಷನ್ ಟು ಆಫರ್ ಕೆನಾಟ್ ಬಿ accepted that not result in agreement. Got it? Invitation to offer is nothing but inviting other person to offer. Invite other party to make an offer. The object of invitation to offer to show his willingness. Show his willingness to deal with any person who on the basis of this invitation ready to enter into the contract. Ready to enter into the contract. It was held in the case of Pharmaceutical Society of Great Britain versus Cash Boot Chemist that all the self-service shops are invitation to offer. It's not an offer at all. So the goods, because what happens here? Sometimes they are selling, right? And what happens? Somebody bought that. If it is offer, if they bought it, if they accepted it, if something goes wrong, ಫ್ಯೂಚರ್ದಲ್ಲಿ ಹೋಗಿ ಏನಾರ ಲಾಸ್ ಆದರೆ ಪಾರ್ಟಿಗೆ ಯಾರು ಖರೀದಿ ಮಾಡಿದಾನೆ ಅವ್ನು ಕೇಸ್ ಆಗಿಬಿಡ್ತಾನವ, ಹೌದಲ್ಲ? ಬಿಕಾಸ್ ಅಲ್ಲಿ ವಸ್ತು ಅದಾವೆ, ಅದು ಬೇರೆ ಬೇರೆ ವಸ್ತು ಅದಾವೆ, ಬೇರೆ ಬೇರೆ ಜನಕ್ಕೆ ಅದಾವೆ. ಇಫ್ ಸಂಬಡಿ ಇಸ್ ಬೈಯಿಂಗ್ ದ ಗೂಡ್ಸ್ ವಿಚ್ ಇಸ್ ನಾಟ್ ಫಾರ್ ಹಿಮ್ ಆರ್ ಹರ್, ಇಫ್ ಯು ಬೈ ಮೀನ್ಸ್ ದ ಪರ್ಸನ್ ಹೂ ಸೆಲ್ಲಿಂಗ್ ಇಟ್ ಕ್ಯಾನ್ ಸೇ ಸರ್ ಆಪ್ಕೆ ನೀ ಹೈ, ನಿಮ್ಗೆಲ್ಲ ಇದು ಅಂತ, ಹೌದಲ್ಲ? ಈಗ ಮೆಡಿಸಿನ್ಸ್ ಅದಾವೆ, ದಾರು ಹೈ, ಖುಷಿ ಜಾಗ ದಾರುಗೆ ಬಾಟ್ಲಿ ಇತ್ತು ಆಫರ್ ಇಲ್ಲ ನಿಮಗೆಲ್ಲ ಅಪೋಸಿಟ್ ಅದನ್ನ. ಬಟ್ ಇಲ್ಲಿ ಇಂಡಿಯಾದಾಗಿಲ್ಲ, ಬಟ್ ಔಟ್ಸೈಡ್ ವಿ ಹ್ಯಾವ್ ಶಾಪ್ಸ್. तू सिगरेट पी लिया तो छोटे बच्चा नहीं देगा बोलता. That's what. So it is invitation to offer. They'll check whether the person who is buying is having potential or not, whether possibility of creating legal relationship is possible or not. That's what. Right? So all the self-service irtalla, it is invitation to offer. Andre yen sariga, the goods on displaying it, right, is not offer. Rather, shops invites public to make offers. Anyone from the public who approach the cashier is desk is nothing but we are making the offer here. Andre ಈಗ ನೀವು ತಗೊಂಡ್ರಿ, again you came back to the shop for payment. There you are making the offer there. ಅಲ್ಲಿ ಏನು ಮಾಡ್ತಿದ್ದೀರಾ, ಆಫರ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ ನೀವು, ಗೊತ್ತಾಗಿದೆಯಾ? There you are making the offer ಬಚ್ಚ. In the above case, Shambhu Dayal had self-service shop. Srimati Prakash selected all the goods and approached the text. The cashier refused to accept the price as the goods on display is an invitation to offer. Right? The cash is not want to sell the goods. So thus, if the cashier does not accept the price, the interested buyer cannot compel him to or cannot force him to sell it. Got it? Now, I think we have discussed this, right? Yesterday. La 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 la. ಅರ್ಥ ಆಗಿದೆಯಾ? Now, Mr. Asim. ಮೊನ್ನೆ ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ವಿ ನಾವು. You want to discuss once again? One. No, right? ಮೊನ್ನೆ ಡಿಸ್ಕಸ್ ಮಾಡಿಲ್ಲ ನಾವು. ಹೌದಲ್ಪ ಕೌಶಿಕ? ಡಿಸ್ಕಸ್ ಆಗಿದೆ ಇದು. ಇದು ಆಗುತ್ತಲ್ಲ? This is also done. ಇದು ಆಗಿತ್ತು. ಪ್ರಿನ್ಸಿಪಲ್ okay. A sent offer to B to sell his second-hand car for 1,40,000 with condition that if he does not reply within a week, A shall treat as an offer. Means mere silence to the offer is not an offer at all. Means bachcho so ille 1,40,000 is the offer that is from A to B with condition that if B does not reply within a week, A shall treat offer has been accepted. Is A correct in his proposition? What shall be proposition if the B communicates his acceptance after 1 week? Okay, but tell me, in first case, if he does not reply 1 week, is that offer is accepted?
No, it should be
communicated. The acceptance should be communicated to the offeree. And after 1 week he communicated means it is nothing but offer is yoked due to time lapse. Right? ಹೌದಲ್ಲ? ಸೊ ಅಂದ್ರೆ ಏನು ಸರ್, ಈಗ ನೋಡಿ, as per the provision of the Indian Contract Act, an offer ಹಿಂಗೆಲ್ಲ ಬರಬೇಕಾಗುತ್ತೆ. When made must not contain non-compliance ಅಂದ್ರೆ ನೀನು ಸೈಲೆಂಟ್ ಆದಿ ಅಂದ್ರೆ ನಾ ಆಕ್ಸೆಪ್ಟ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹಂಗಿಲ್ಲ, ವಿಚ್ ಶುಡ್ ಅಮೌಂಟ್ ಟು ಆಕ್ಸೆಪ್ಟೆನ್ಸ್. ಹೌದಲ್ಲ? ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಅಂದ್ರೆ ಕಂಪ್ಲೈನ್ಸ್ ಇರಬೇಕು, ಅದಕ್ಕೆ ಫಾಲೋ ಮಾಡಬೇಕಾಗುತ್ತೆ, ಆಕ್ಸೆಪ್ಟೆನ್ಸ್ ಬೇಕು, ಕಮ್ಯುನಿಕೇಟ್ ಆಗಿರಬೇಕು. ಇದಿಲ್ಲಪ್ಪ ಇಲ್ಲ ಅಂದ್ರೆ ನಡೆಯಂಗಿಲ್ಲ. ದಟ್ ಈಸ್ ನಾಟ್ ಕಂಪ್ಲೈನ್ಸ್, ರೈಟ್? ಸೊ ದ ಆಫರರ್ cannot put condition. The offerer cannot put a condition that if the offeree does not fulfill the specified condition, it shall be deemed to be ಏನಾಗುತ್ತೆ, deemed to be that the offer has accepted the offer. ಹೌದಲ್ಲ? ಸ್ವಲ್ಪ ನೋಡ್ರಿ. So the offer cannot put a condition that if the offeree does not fulfill a specified condition, it shall be deemed that the offer has been accepted. ಹಿಂಗಿಲ್ಲ ಕಂಡೀಷನ್ ಬರೋದು. ಹೌದು ಇಲ್ಲ? Yes or no? So now, because of non-compliance, further acceptance to an offer cannot be implied merely from silence. Acceptance cannot be implied by becoming a silence. But if the party has done previously, in that case, okay, you can manage it. ಮುಂಚೆ ಅವ ಮಾಡಿದಾನೆ, ಪहिले किया ಅವನೇ, ಮುಂಚೆ ಅವ acceptance was result in, sorry, silence was result in acceptance ಇದ್ದಾಗ, in previous case, previously if past he has done, then you can accept. But here, even if it is expressly stated in the offer itself, you cannot say that offer is accepted by mere silence. Mere silence does not result in acceptance. Unless the offer has previous conduct, previously has conducted, indicated that his silence amounts to accept. It cannot be taken as a valid acceptance. In given case, A sent offer to B to sell his car with the condition that if B does not reply, if B does not reply, A will consider acceptances. We cannot. So as offer cannot be contain such conditions here of non-compliance, B silence cannot be treated as acceptance here, right? So thus B silence does not result into a contract between A and B, even if B accept the offer, even if the B accept the offer is not valid here, right? While the contract of offer is not valid here. ಗೊತ್ತಾಗಿದೆಯಾ? ನೋಡ್ರಿ, B's silence does not result in any contract here because A's offer cannot contain such conditions that B's silence cannot be treated as acceptance here. Obviously, contract ಅಲ್ಲಿ acceptance ಬೇಕಪ್ಪ ಅಂದ್ರೆ guys, you cannot consider it as a silence, cannot be a acceptance here. ಗೊತ್ತಾಯ್ತು? Understood? ಅರ್ಥ ಆಗಿದೆಯಾ? Thus B silence does not result into contract between A and B, even if B accepted the offer by becoming a silence, not a valid contract ಆಗುತ್ತದೆ. Not a valid contract ಆಗುತ್ತೆ, as the offer is not valid here. ಹೌದಿಲ್ಲ? Yes or no? ಅರ್ಥ ಆಗಿದೆಯಾ? Next, comment on the following statement. Acceptance must be absolute, unqualified. Acceptance must be prescribed mode. Yeah. Just now discuss ಮಾಡಿದ್ವಲ್ಲ ಈಗ ನಾವು. ನೋಡಿ, acceptance must be absolute, unqualified. As per ನೋಡಿ ಈಗ unqualified ಅಂದ್ರೆ ಏನು? ಅದು very important part ಇದೆ acceptance. As per section 7 of the Indian Contract Act 1872, acceptance is valid when it is absolute and unqualified and also expressed in some usual and reasonable manner, unless the proposal prescribe the manner in which it must be accepted. Very important ಬಚ್ಚು. ಅಂದ್ರೆ ಏನ್ ಸರಿ ಇಲ್ಲ, ಕೇಳ್ರಿ, ಯಾವತ್ತು acceptance ಕಂಪ್ಲೀಟ್ ಆಗಬೇಕಂದ್ರೆ ಆ ಆಫರ್ದಲ್ಲಿ ಸ್ಪೆಸಿಫೈ ಮಾಡಿದ್ದಾರೆ ಈ ರೀತಿ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಪ್ಪ ಅಂತ, ಅವಾಗ ಅದೇ ರೀತಿ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಬೇಕು. ಇಫ್ ಇಟ್ ಈಸ್ ನಾಟ್ ಎಕ್ಸ್ಪ್ರೆಸ್ಡ್, ಇನ್ ದಟ್ ಕೇಸ್ acceptance must be absolute and unqualified ಇರಬೇಕು, right? If the proposal prescribed the manner in which it must be accepted, then it must be accepted accordingly. ಹೌದು ಇಲ್ಲ? ಪ್ರಪೋಸ್ ಹೇಳೋಣ ಈ ರೀತಿ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಬೇಕು, ಅದೇ ರೀತಿ ಇಲ್ಲ ಅಂದ್ರೆ should be absolute and unqualified. Other A inquired from B, will you purchase my car for 2 lakh? If B replies, I shall purchase your car for 2 lakh if you buy my motorcycle for 50,000. Here B cannot consider to have accepted the proposal. Yes or no? Because ನೋಡಿ, very important point ಇದೆ ಇಲ್ಲಿ ಎಕ್ಸಾಮ್ದಾಗ, ಇದು ಪ್ರಾಬ್ಲಮ್ ಎಲ್ಲ ಡಿಟೇಲ್ ಆಗಿ ಹೇಳ್ತಾರೆ ನೋಡಿ. Because you may get confused here, what exactly absolute and what is exactly unqualified. ಇಲ್ಲಿ ಏನು ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ, ಎ ಆಫರ್ ಮಾಡಿದಾನೆ ಬಿಗೆ, ನನ್ನ ಕಾರ್ ಖರೀದಿ ಮಾಡಪ್ಪ 2 lakh ಅಂತ. ಬಿ ರಿಪ್ಲೈ ಮಾಡಿದಾನೆ, ಐ ಶಾಲ್ ಪರ್ಚೇಸ್ ಯುವರ್ ಕಾರ್ ಫಾರ್ 2 lakh. ಓಕೆ, ಐ ವಿಲ್ ಬೈ ಇಟ್ ಯುವರ್ 2 lakh car, but if you buy my motorcycle car for 50,000. Here B, not A, B cannot be considered to have accepted the proposal, right? A has proposed to B and B has A, for A's proposal B has given some other offer, right? That does not mean B has accepted the A's proposal here. ಹೌದೋ ಇಲ್ಲ? Yes or no? So if on the other hand B agrees to purchase the car from A as per his proposal by paying 2 lakh, but the car should have valid registration certificate or book, RC book, that is what conditional ಆಗುತ್ತೆ. Accepted ಇದೆ and valid ಇದೆ, ಹೌದಾ? It is valid means then the acceptance is placed through the offer contain the no mention of RC book. This is because expecting valid title for the car is not a condition at all. ಗೊತ್ತಾಗಿದೆಯಾ? Therefore the acceptance in this case is unconditional. ಅರ್ಥ ಆಗಿದೆಯಾ? ಅರ್ಥ ಆಗಿದೆ ಬಚ್ಚೋ? ಏನಪ್ಪಾ ಹೌದಲ್ಲೋ ಮರಯ, ಏನ್ ಕಾಡ್ಸಾಕತ್ತಪ್ಪ ಇದು. ಇದು ಕಾಣಬೇಕು. ಅರ್ಥ ಆಗಿದೆ ಇದು? ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಮಸ್ಟ್ ಬಿ ಅಬ್ಸಲ್ಯೂಟ್ ಅಂಡ್ ಅನ್ಕ್ವಾಲಿಫೈಡ್. ಈ ರೀತಿ ತಗೋಬೇಕು. ಅಂದ್ರೆ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ಗೆ ಕಂಡೀಷನ್ ಹಾಕಿ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಬಾರ್ದು. ಆಫರ್ ಹೆಂಗಿರುತ್ತಲ್ಲ ಅದರ ಪ್ರಕಾರ ನಾವು ಆಕ್ಸೆಪ್ಟ್ ಮಾಡಬೇಕು. ಆಫರ್ದವ್ರು ಕಂಡೀಷನ್ ಹಾಕಿದ್ದಾರೆ, ಅದು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಡ್ರಿ, ಅಕಾರ್ಡಿಂಗ್ ಟು ದಟ್ ಓನ್ಲಿ ಆಕ್ಸೆಪ್ಟ್. ನೀವು ಆಫರ್ ಮೇಲೆ ಮತ್ತೆ ಕಂಡೀಷನ್ ಹಾಕಿದ್ರೆ ನಾನು ನಿಮ್ದು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ತೀನಪ್ಪ ಹಿಂಗೈತೆ ಅಂದ್ರೆ ನಡೆಯಂಗಿಲ್ಲ. ಯು ಕೆನಾಟ್ ಅಕ್ಸೆಪ್ಟ್ ಇಟ್. ದಟ್ ಇಸ್ ವೈ ಬಚ್ಚೋ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಈಸ್ ಅಬ್ಸಲ್ಯೂಟ್ ಅಂಡ್ ಅನ್ಕ್ವಾಲಿಫೈಡ್. ಅರ್ಥ ಆಗಿದೆಯಾ? ಡೌಟ್ ಇಲ್ವಾ? ಮತ್ತೆ ಇದಂತೂ ಗೊತ್ತಿದೆ ನಿಮಗೆ. ಸಬ್ ಟರ್ಮ್ಸ್ ಇದಾವಲ್ಲ, that makes little bit confused here. Acceptance must be prescribed mode. Acceptance ಇದಾವಲ್ಲ must be prescribed mode. Where mode of acceptance is prescribed in proposal, it must be accepted in the manner. But if the proposal does not insist the proposal to being accepted in the manner prescribed after it has been accepted, otherwise that is not prescribed manner, the proposal is presumed to have a consented acceptance. ಅಂದ್ರೆ ಏನು, ಈಗ ಒಂದು ಆಫರ್ ಕೊಟ್ಟಿದ್ದಾನೆ, ಒಂದು ಪ್ರಪೋಸಲ್ ಇದೆ, ಆ ಪ್ರಪೋಸಲ್ದಲ್ಲಿ ಒಂದು ಮೆಥಡ್ ಇದೆ, ಈ ರೀತಿ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ರಿ ಅಂತ. ಈಗ ಅಕ್ಸೆಪ್ಟೇ ಮಾಡಿದಾನವ, ಬಟ್ ಆ ಮೆಥಡಲ್ಲಿ ಇಲ್ಲ. ಆಫರ್ ಮಾಡಿದವ ಅದಕ್ಕೆ ಸೈಲೆಂಟ್ ಇದ್ದಾನೆ, ಅದ್ರ ಬಗ್ಗೆ ಏನು ಫೋರ್ಸ್ ಮಾಡ್ತಿಲ್ಲ. ಆಯ್ತು ಬಿಡಪ್ಪ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿದಾನೆ ಮುಗೀತು ಅನ್ನಂಗಿಲ್ಲ. ಎಸ್ ಯು ಕ್ಯಾನ್ ಅಕ್ಸೆಪ್ಟ್ ಇಟ್. ಏನದು? ಎಸ್ ಯು ಕ್ಯಾನ್ ಕನ್ಸಿಡರ್ ಇಟ್ ಇಸ್ ಅ ವ್ಯಾಲಿಡ್ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್. ಗೊತ್ತಾಗಿದೆಯಾ? ನೋಡಿ ಎಕ್ಸಾಂಪಲ್, ಇಫ್ ದ ಆಫರರ್ ಪ್ರಿಸ್ಕ್ರೈಬ್ಡ್ accept through the messenger and offer is sent acceptance by email, there is a no acceptance of the offer. If the offerer, the first party, informs the offeree that the acceptance is not according to the mode, ಅವ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿರ್ಬೇಕವ. ಬಟ್ if the offeree fails to do that, if ಅವ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿಲ್ಲ, it will presume that he has accepted the acceptance and while contract is taken place. ಅಂದ್ರೆ ಏನ್ ಸರ್, ಈಗ ನೀವು ನಿಮ್ಮ ಹತ್ರ ಒಂದು ಮನಿ ಇದೆ ಅಥವಾ ಇನ್ನೊಂದು ಪ್ರಾಪರ್ಟಿ ಇದೆ, ದಾಟ್ ಯು ವಾಂಟ್ ಟು ಸೆಲ್ ಫಾರ್ 1 lakh 10 lakh rupeesಗೆ ಆಫರ್ ಮಾಡಿದ್ವಿ. ಅವ ಏನು ಮಾಡಿದಾನೆ, ಅವನಿಗೆ ನಿಮ್ಗೆ ರಿಪ್ಲೈ ಮಾಡಿದಾನೆ, ಇವಾಗ 2 lakh rupees ತಗೊಡ್ರಿ, ಆಮೇಲೆ ನಿಮ್ಗೆ 8 lakh ರೂಪಾಯಿ ಕೊಡ್ತೀನಿ ಆಫ್ಟರ್ 1 week. ಸೊ ಈಗ ಇದು 2 lakhs ತಗೊಂಡು ಸುಮ್ಮನೆ ಕುಂದ್ಬಿಟ್ರಿ ನೀವು. ಅಂದ್ರೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ಬೇಕಿಲ್ಲ, ಒಳ್ಳೆಪ್ಪ ನಾನು ಬೇಡ ಅಂತ. ಯು ಆರ್ ನಾಟ್ ಅಪ್ಡೇಟೆಡ್ ಹಿಮ್. ನಾ ಆಫರ್ ಮಾಡಿದ 10 ಲಕ್ಷಕ್ಕೆ 10 ಲಕ್ಷ ಒಪ್ಕೊಂಡಿದ್ಯಾ, ಬಟ್ ಪೇಮೆಂಟ್ ಪಾರ್ಟ್ ಮಾಡ್ತಾ ಇದೀಯಾ. ಇಫ್ ಯು ಆರ್ ನಾಟ್ ಇನ್ಫಾರ್ಮಿಂಗ್ ಹಿಮ್, that means you have the acceptance is wild ಆಗ್ಬಿಡ್ತೈತಿ. ಇಫ್ ಯು ಇನ್ಫಾರ್ಮ್, ಇಲ್ಲ 2 lakh rupees ನಾ ತಗೊಳಕ್ವಲ್ಲೇ, ನಂಗೆ 10 lakh ಬೇಕಂದ್ರೆ ಆಫರ್ ಏನಾಗುತ್ತೆ, ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ರಿಜೆಕ್ಟ್ ಆಗ್ಬಿಡುತ್ತೆ. ಗೊತ್ತಾಗಿದೆಯಾ? ಇಫ್ ನೀವು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಆಗ್ಬಿಡ್ತೈತಲ್ಲ. ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಆದ್ರೆ ವ್ಯಾಲಿಡ್ ಕಾಂಟ್ರಾಕ್ಟ್. ಹೌದಾ ಇಲ್ಲ? ಎಸ್ ಆರ್ ನೋ ಬಚ್ಚಾ? ಅದು ಅವ್ರು ಹೇಳ್ತಾರೆ ನೋಡಲ್ಲಿ. Define the term under the Indian Contract Act 1872. Explain the legal rules regarding valid acceptance. In terms section 2 subsection B of the Indian Contract Act 1872. 1872. The term acceptance is defined when the person to whom the proposal is made signifies his assent to that the proposal is said to be accepted. When the proposal is accepted, it becomes promise. ಬರಿಬೇಕಾಗತ್ತೆ, ನೆನಪಿಟ್ಕೋಬೇಕಾಗತ್ತೆ, ಒಂದಲ್ಲ ಎರಡಲ್ಲ 10 ಸತಿ ಓದಬೇಕಾಗತ್ತೆ. You should write it again and again. The following are the legal rules regarding the valid acceptance. Acceptance can be given only the person to whom the offer is made. ಹೌದಲ್ಲ, ಯಾರಿಗೆ ಆಫರ್ ಕೊಟ್ಟಿರ್ತಲ್ಲ ಅವನೇ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಹೋಗಬೇಕು, ಬೇರೆ ಬರೋದಿಲ್ಲ. Acceptance must be absolute and unqualified. ಲಾಸ್ಟ್ ಕ್ಲಾಸಲ್ಲಿ ಹೇಳಿದೆ ನಿಮಗೆ ನಾನು, ರೈಟ್? Acceptance must be communicated. Acceptance ಮತ್ತು ಇನ್ಫಾರ್ಮ್ ಮಾಡಬೇಕು. Acceptance must be prescribed mode, right? Yes or no? Time. Just now we discussed, right? Time. If the in offer they mention the time means definitely you have to. If there is no time is mentioned, reasonable time is very important here. Reasonable time is important. Mere silence is not acceptance here. Correct? Howdilla? Other day we discussed now. Acceptance by conduct implied acceptances. When you are retaining that product, you are accepting it, that acceptance type. Next. State various modes of revocations. Just now discussed, right? Howdilla? Revocation ಹೆಂಗಾಗುತ್ತೆ? Section 6 of the Indian Contract Act 1872 deals with various modes of revocations of offer. An offer may be revoked in any of the following: by notice of revocation, by lapse of time, correct? Yes or no, bachcho? By non-fulfillment of condition precedent. As per the offer, if you are not fulfilling the conditions, by death or insanity, by counter offer, by non-accepting the offer of the according to the prescribed or usual manner, by subsequent of the illegality. Now, Mr. B makes a proposal to A, Mr. S. He has made an offer to S by post to sell his house for 10 lakh and posted the letter of 10th April 20. And letter reaches Mr. S on 12th. 12th reach agide. He reads the letter on 13th. 13th read agana. Mr. S sent his letter of acceptance on 16th accept madame. And letter reaches to the B on 20. On 17th, Mr. S changed his mind and sent a telegram withdrawing his acceptance. Telegram reaches that on 19th. 20 ಗಿಂತ ಮುಂಚೆ ಮಾಡಿದ್ರೆ examine with reference to the Indian contract. On which date offer made by Mr. B will be completed? When he reads that. When he reads bacha? He reads letter on 13th. Right? ಹೌದಲ್ಲ? ಕಳಿಸಿದ ದಿವಸ ಅಲ್ಲ, ರೀಚ್ ಆಗಿದಲ್ಲ 13th ಗೆ. 13th ಗೆ ಏನಾಗುತ್ತೆ? ಆಫರ್ ಈಸ್ ಕಂಪ್ಲೀಟ್ ಆಗುತ್ತೆ. ಡಿಸ್ಕಸ್ ದ ವ್ಯಾಲಿಡಿಟಿ ಆಫ್ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್. ರಿವೋಕೇಶನ್ ಆಗುತ್ತೆ. Right? Because telegram reach acceptance is taken place when he send the letter in terms of B, because B is bonded here. Once the acceptance is sent, finished. Whether letter reach or not reach, a wrong address, anything we don't want to be wrong address, correct address. But discuss the validity of acceptance, but it can be revoked. It is cancelled. What would be the validity of acceptance if the letter revocation letter of the acceptance reach together when he reads it? Exactly. According to section 4 of the Indian Contract Act 1872, the communication of offer is completed when it comes to the knowledge of the person to whom it is made. When it's made. So when proposal is made by post, its communication will be complete when the letter containing the proposal reaches to the person to whom it is made. Further, mere receiving the letter is not sufficient. He must receive the letter, read the message and containing the letters. He should read it. here where a proposal is accepted by the letter sent by post in terms of section 4 of the Act, the communication of acceptance will be completed against the proposal when the letter of acceptance is posted in case of whom the person who made the proposal, and against the acceptor when he letter the reaches to the proposal. Bachcho, the acceptor can revoke his acceptance anytime before the letter of acceptance reaches to the offerer. If revocation telegram arrives before at the same time, the letter acceptance revocation on absolute when he reads it. In the given question, B makes a proposal by post on to S to sell his house. The letter was posted on 10, letter reaches on 12, but reads on 13. So S sends his letter of acceptance on 16 and reaches that Mr. B on 20. On 17th, change his mind and send a telegram. The telegram reaches on 19th here. Right? So that means, bacha, the offer made by B will be complete on the when he read the letters. That is 13th. Yes or no? Yes or no, bacho? Next, the communication of acceptance against Mr. B is complete on 16th. Howdala? 16th, when the letter is posted. As against, acceptance will be complete when the letter reaches to B on 20. The acceptor will bond by his acceptance only when the letter of acceptance reaches to the proposer, the person who has made offer. The telegram of revocation is reached before the post, that is 19, before the letter of acceptance of 20. Hence, the revocation is absolute here. So, therefore, acceptance of offer is invalid here. Got it? So, now, it will not make any difference even if the telegram of revocation and letter of acceptance would have reached the same day. That is, revocation of revocation, that is the revocation then also would be have been absolute. As per the law, the acceptance can be revoked anytime before the communication of acceptance is completed. That means reached to the offerer. Since revocation was made before the communication of acceptance was complete, and communication can be considered as a complete only when the letter of acceptance reaches to the proposer. Right? Artha ಆಗಿದೆಯಾ? Understood? No doubt? So consideration, next chapter will start now. We have next chapter now.
Now it starts.
I want to consideration. ಇವಾಗ ಏನು ಅಕೌಂಟ್ಸ್ ಒಳ್ಳೆ ಮಾಡಿ? Yeah. First unit is done, bacho. Second unit is nothing but consideration we have. Get ready. ನಾನು ಶೇರ್ ಮಾಡ್ತೀನಿ ಅದೆಲ್ಲ. Please ಒಂದು ಬರೀರಿ ಒಮ್ಮೆ 2 ಸತಿ 3 ಸತಿ ಬರೀರಿ. So then only it can reach us. Chalo guys, definitely result announce ಆಗ್ತಾ ಇದೆ, ಚೆನ್ನಾಗಿರ್ಬೇಕು.